Okay, hi, this is Greg McIntyre with McIntyre Elder Law, helping seniors protect their assets and legacies. And we're here to talk today about probate. Probate is the process, probate and estate administration is the process you go through if you die with a will or without to change title to assets. Changing title to assets could be changing ownership of real estate, or changing ownership of vehicles, or changing ownership of bank accounts and other investments. It could be changing ownership of retirement accounts. Ways to avoid probate. So first, the probate process. If you have a will that passes your property, the probate process is what you go through to pass property through that will. You'll go to the courthouse, you'll say, Madam Clerk, here's my loved one's will. This is actually a long-term care insurance brochure, but let's pretend this is your loved one's will. And what do I do? Well, the clerk is legal advice. They'll tell you that, but they may be able to hand you some out to get started. But it's up to you to navigate the process, and I hope you do so correctly. If you have any questions ever about the probate process, or it's too overwhelming, because sometimes when a loved one dies, it's never a fun time. It's never a good time, but it's a hard time. Sometimes it's a hard time. And we don't want to complicate that process by having you go through a conflicted probate process or a long drawn out expensive probate process, or one where you're not familiar and unable to navigate those waters. That's something we do on a daily basis at McIntyre Elder Law. You can always give us a call, 704-259-7040, and we will help. So, the probate process. You're going to put forth the will to be probated. Now, that will needs to be written correctly. If it does not comply with the will's statutes, then it's not going to be allowed to be probated. It needs to be the original of the will. It needs to be self-proving, or else the witnesses will have to show up and testify that they saw you sign, or have to sign affidavits that they saw you sign after you pass away. So those are things you want to check in estate planning or pre-planning prior to passing away, right? We want to get those things squared away, get those foundational documents squared away. So in the probate process, assuming letters of probate are issued to the executor, you have to qualify to be the executor of someone's probate estate. Then once those probate letters are issued, we have to publish in the paper if it's a normal, regular estate and not what I call an estate by affidavit or small estate. Then it has to be published in the paper that this person passed away 4 consecutive weeks, and then 90 days from the first day it's published, we can close out the lien period. Now that 90 days is open so that anyone that you owe money to during your life can attach a lien to your estate. That's where many people get into trouble and lose assets. If you've had health care liens, other debts during your life, or if Medicaid had to come in because you did not have long-term care insurance, right? If Medicaid had to come in and pay for assisted living or nursing home care, then that lien would attach during that period as well and force the sale of, say, a home that might still be in your possession. That's why avoiding probate, protecting assets with deed work like life estate deeds, ladybird deeds on the home, can really act to protect that property to for the family and not subject it to the probate process. So many people, how about we need to clarify the difference between probate property and non-probate property. Probate property, again, are assets that need the title changed through the probate process. It's got to be legally changed somehow, unless you have it otherwise set up to change title to properties or vehicles or bank accounts outside of probate, which can be done by adding payable on death beneficiaries on bank accounts, or joint tenants with rights to survivorship, joint owners with rights to survivorship on bank accounts, or joint tenants with rights to survivorship on cars now with a form called an MVR 620. That's MVR 620. So You could also add beneficiaries to your life insurance policies, which passes outside of probate, or to IRAs, 401ks, retirement accounts. Those are separate than probate assets. Or we could look to trust to avoid probate. Trust can gather everything and pass it outside of the probate process, outside of that lien process, outside of the courthouse process. Probate is a public process with a public file that anybody can access at the courthouse. Trusts are not. Trusts are private and administered generally by the trustee or in an attorney's office with everyone sitting around the conference table. So those are some of the differences in probate and non-probate assets and strategies. So assuming that you make it through the 90-day lien period, no liens have attached, you can come out of the other end of that and then disperse to the heirs. That's if also no one has contested the will, which is called a will contest suit. We handle probate litigation. I like to go to court. I enjoy the strategy. And that is something that is sometimes horrific for families when families are fighting over assets and they can't agree upon the distribution of assets, or they don't agree with a will, and the families are left to fight over that in the court process, which is called a will caveat suit, okay, or a will contest suit, okay? So if you need help with contesting a will ever, give us a call on that too. We'll certainly evaluate your case, 704-259-7040, or visit us online at mcelderlaw.com/probate. mcelderlaw.com/probate. That will tell you more about the probate process if you go to that website, and it'll also allow you to contact us and access us or chat right back and forth with us right there on the website and on that web page. So that's a little bit about the probate process. There are some inventories that need to go on in there. There's a 90-day inventory. There could be an annual inventory if it goes on more than a year, and final inventories to finally close it out. And if you're worried about your executor running off with the funds, there are some reasons and some stop gaps and safeties nets that can be employed there. We could require the executor to post bond. That means that there's an insurance bond that if the executor misused the funds would cover and reimburse any heir for the misuse of those funds. That can be written in the will. Also, the clerks at your local courthouse are going to really monitor what the executor does. That's why those inventories are in place, and also the finals in place. So they have to actually approve everything that happened, and that it happened exactly as the will said it was supposed to happen. Also, the other heirs have to sign off that they received their inheritance, their just due. So there's the other heirs have some say-so in there as well. So don't feel powerless if you're not the executor, and don't feel worried if you've made someone an executor of your will. There are other eyes on that process that will help administer that process and move it along. You're certainly entitled to representation as the executor and to probate the will. And again, if you need to contact us, go to mcelderlaw.com/probate or call us at 704-259-7040. We handle everything from the estate planning, the will drafting, the trust drafting, the strategic piece of probate avoidance and asset protection, from real estate to retirement, and also handle the probate process as well as probate if there are ever any problems. Thank you so much for listening. I'm Greg McIntyre, the Elder Law Guy at McIntyre Elder Law, helping seniors protect their assets and legacies, and you have a great day.